Welcome to the MOOC lecture. Today's topic is Prevention of Atrocities on Scheduled Castes and Scheduled Tribes, Ethnic and Religious Discrimination. All of us know that India is a country where rule of law governs. And here the principles of liberty, equality, dignity are highly cherished and elegantly enshrined in the Constitution of India. But if we look into the matters properly, then we will find that these principles are not strictly followed, are not adhered to towards certain people because they are handicapped socially, culturally, religiously, economically, to challenge such discrimination and such inequality. There are various reasons where certain people cannot enjoy their right to water from certain lake, certain spring, certain streams, just because they are people belonging to scheduled caste and scheduled tribe. Some instances happen in such a remote areas that outsiders cannot access to these people for hearing their problem. Because of this, all these incidences don't find any mention in newspaper report. But since long years, these people who belong to scheduled caste and scheduled tribe have been facing all such violences, discrimination, and this is the time to change all such discrimination. And it requires the participation of judiciary, active participation of legislature, as well as the cooperation of concerned citizen. Recently, in August 2022, in Jharkhand, Palamu district, more than 50 village families had been driven out from their village where they were staying since long 150 years. And all of them belong to scheduled caste. Again, one heart-touching incident took place very recently, that is 2022 November, where in Bihar, Arwal district, a young woman of 26 years was burned to death because some people belonging to so-called upper caste tried to molest the women and she resisted the incident. If we will looking towards the record of National Crime Record Bureau, then we will find that these cases are increasing. 2021 and 2020, the ratio of increase is 1.2%. And in 2021, 50,291 cases were registered against the people belonging to scheduled caste. Again, if we will be going towards the scheduled tribes, then also we will find that cases of atrocities are increasing. And the ratio of that particular increasement is 6.4%. It means in 2020, it was 8,272 and in 2021, it was 8,802. If we will going towards the history of such atrocities, then we will find that it is rooted in our history. But Srimad Bhagavad Gita has not said anything regarding such discrimination. It was the creation made by later various scripts like Manusmriti and other Dharmasastras. Srimad Bhagavad Gita mentioned that Saturvarnam Maya Srishtham Guna Karma Vibhavasa. It means that the caste is determined on the basis of the performance and the profession of the people. But these practices had been changed with the passage of time because of evolution of new norms, new values, new religious as well as cultural practices as had been adopted by the various dynasties. It means Vaishya, Sudra, Kshatriya and Brahmana. All these people had been created not by the Vedic scripts but later on various Smritis or Dharmasastra like Manusmriti. This way the division came into existence. If we look towards the scheduled tribes, we will find that they are the people who started living a beast life in harmony with nature since long period of time. And one anthropological study made by Oxford University has revealed that the first human beings started living before 1,20,000 years back, and the people who migrated from Africa to India, perhaps the first tribal people. And today we consider them as a scheduled tribe. They do have their distinct culture, distinct language, distinct world perception. If we will be taking the reason, then we will find that the reasons are varied. Sometimes it depends upon social practices. Sometimes it depends upon the religious practices. Sometimes there are certain economic factors are there which decides the various forms of atrocities. In one famous Supreme Court judgment, it has been suggested that these people belonging to scheduled caste and scheduled tribe, they are basically poor, and because of poverty, they have to depend upon the so-called upper caste people. And because of this reason, they lost their dominance, influence, and command on social, cultural, and economic rights. We will also find that our traditional values have been also forming such kind of discrimination, that people belonging to scheduled castes are basically pollutant and inferior, and they cannot enjoy their right to go to the temple, right to offer puja in some religious occasion, and right to go for collecting water from some stream, some lake, some pond. If they will collect, then the water will get polluted. Because of certain norms, values, and religious belief also. It has been going on since long that if people belonging to scheduled caste will collect the water from the pond, from the lake, from the stream, then it will get polluted. Thus, since last 100 years of age, because of various reasons, they have been deprived of from their right to participate in various cultural affairs, participate in religious rituals, practices, and even they are compelled to dispossess from their right over their land, right to cultivate on the land, just because they are poor, they are ignorant, they cannot approach others to enjoy their right. Since long time, these members of scheduled castes and scheduled tribes are denied of exercising certain rights, like right to access water from the sources where others use it, right to enjoy common public transportation, right to cultivation of his own land, right to ownership over the land, right to fair trial, right against custodial torture, right to free and speedy justice, right against honor killing, etc. If we will be going towards the constitutional provision against all these forms of atrocities, then we will find that various provisions have been there in the Constitution which are protecting the interest of these scheduled castes and scheduled tribes people. Article 14 speaks that all individuals similarly situated are entitled to equality before law and equal protection of the law. Article 15 speaks about the prohibition of practices relating to restriction of person on the ground of race, religion, place of birth, gender, to enjoy public road, public restaurant, water pond, and all such places of public entertainment which have been made out of state fund. Article 15 clause 4 speaks about the responsibility of the state to frame special legislation for the protection of the interests of members belonging to scheduled castes, scheduled tribes, and other backward classes. Article 16 also speaks about the responsibility of the state to frame special provision for the protection of interests of such people. Article 21 speaks that all the practices which are derogatory to the dignity, fraternity of all such people belonging to scheduled caste and scheduled tribe are prohibited. Article 21A speaks about the right to education of all children belonging to. Article 21 speaks about the right of the children below the age of 6 to 14 years to education. Article 23 speaks about the prohibition of practices which are derogatory to human dignity. It speaks about the restriction of forced labor, traffic in human being and beggar. Article 17 of the Constitution of India, if we will be looking towards the constitutional provisions regarding protection of scheduled castes and scheduled tribes, then we will find that bundle of rights have been added in our constitution, which speaks about the protection of such people against inhumanity, derogatory practices, as well as all kinds of discriminatory treatment. Article 16 clause 4 allows the state to make provision for the reservation of appointment towards the people who are not adequately represented in such services. Article 21 speaks about right to life and personal liberty, under which it is very much clear that all the practices which is derogatory to humanity, dignity, fraternity of the people is amounting to violation of Article 21. Article 17 is there in the Constitution, which guarantees rights against untouchability. It speaks that caste-based disability is an offense under the law. Article 23 guarantees protection of individual against traffic in human being, forced labor, as well as beggary. Article 24 speaks about prohibition of engagement of children below 14 years of age in hazardous practices. Article 43 speaks about living wages as well as protection of the decent standard of life to all workers, agricultural as well as industrial. Article 46 of the Constitution make it very much clear that state should protect the interest of the people belonging to scheduled caste and scheduled tribe against humiliation, injustice as well as exploitation. If we talk about the special legislation for the protection of such people belonging to scheduled castes and scheduled tribes against atrocities, then we will find that immediately after independence, Indian Parliament started making law to prevent such derogatory practices. The first law came into existence for the protection of such people against untouchability is the Untouchability Offences Act 1955. It speaks that all the practices which will give rise to caste-based disability is punishable under the law. And if anyone will deny the charge which is made against him under this law of 1955, then he has to produce evidence before the court that he has not committed the offense of untouchability. Otherwise, he will be punished according to this law. Then in the year 1976, this Untouchability Offences Act took its new shape and it took the shape of Protection of Civil Rights Act 1955. 5. Here, specifically, various activities have been mentioned as offenses. For example, if anyone will deny the people from his right over the land, if any person will prohibit such people belonging to scheduled caste and scheduled tribe to cast his right to vote, and if will restrict his right to use any water sources like spring, stream, pond, cistern, then it will be amounting to offenses, where punishment is given 6 months as well as fine. Again, certain other activities has been made as an offense under this Act of 1955. That if any person will involve in any activities which will be amounting to the derogatory to the right of such people relating to enjoyment of certain religious rituals, enjoyment of certain dharmsala. Further, the Protection of Civil Rights Act speaks that any caste-based practices like insulting to a member is amounting to offense, and obstructing, annoying, injuring, molesting a person belonging to scheduled caste and scheduled tribe is an offense, punishable under the law of 1955. But it has been realized after the recommendation of National Police Commission, which had been made in the year 1979, that the act is not sufficient to protect the rights of the people belonging to scheduled castes and scheduled tribes. And still, the offenses were going on against them. And finally, in the year 1989, Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act came into existence, which has specifically mentioned 25 number of activities which are amounting to atrocities, which includes various provisions relating to the relief, rehabilitation of the victim of such offenses. It speaks about speedy disposal of cases under this law. It speaks about protection of women against various derogatory practices, which are amounting to atrocities against such people. The Act speaks that engagement of the people belonging to scheduled caste and scheduled tribe in activities like removal of human carcasses, animal extract, umbilical cord, and manual scavenging, these are punishable under law. Dispossession of a person from their land, from their premises, is amounting to violation of this legislation. Putting of obnoxious items in their mouth, like urine, human excreta, these are amounting to offense. Compelling the person to be naked, painting over such person, calling the person in his caste name, tribe name, these are offenses. Here, specific punishment is made, which is 6 months or fine and may extend up to 3 years in certain cases. In the year 2015, the Act has been amended and certain new provisions came, For example, garlanding of such people by other people is amounting to offense. And touching of the people who belong to this scheduled caste and scheduled tribe is an offense. Showing any kind of sexual gesture to a woman belonging to so-called Dalit or Adivasi is amounting to offense. It also speaks about establishment of exclusive special court as well as exclusive public prosecutor office for speedy disposal of such cases as well as proper implementation of those schemes which speaks about the rehabilitation of the victim. Apart from these legislation, in 2013, employment of manual scavengers and construction of dry latrine Prohibition Act has been come into existence, which speaks about the restriction of people in engaging of certain activities like collecting of human excreta with bare hands, manual scavenging, and works which are derogatory to their human prestige and dignity. It again speaks about that government will make certain service for collection of data regarding how many people are engaged in such manual scavenging activities, and they will be later rehabilitated with certain amount of fund. Recently in 2013 and 2018, government has made survey, and the persons who had been found engaging in such activities had been given 40,000 rupees per person. If we will be looking towards the protection of judiciary, then we will find that lots of judgments are there where Honorable Supreme Court, various high courts are speaking about the protection of the interests of such people belonging to scheduled castes and scheduled tribes against various forms of atrocities, discrimination, disability, liability, prohibition as well as restriction. State of Gujarat versus Vaghela Dayabhai Chaturbhai judgment, where Supreme Court has said that the land resolution of the government should be disposed of, giving priority to the people who are belonging to scheduled caste as well as scheduled tribe, who don't have land more than 5 acres. Again, we do have another judgment, Manju Devi versus Omkarjit Singh Ahluwalia, where Supreme Court set aside the High Court order and said that the accused who are booked against the Atrocities Act, they cannot be given anticipatory bail. Again, in one another judgment, S. Senkoti versus Joint Director is another very landmark judgment, where the Honorable Court speaks about the decision of the Khap Panchayat and said that if the decision of the Khap Panchayat is amounting to violence against the so-called Dalit or Adivasi people, then that should be set aside. The state administration have to take special care against such decision. In the year 2017, a huge issue came regarding the misuse of the act, and the Supreme Court has to try one issue in the case of Subhas Kasinath Mahajan versus Union of India. Here, regarding the misuse, it has been observed by Supreme Court and said that before arresting of a person under the Act of 1989, there should be preliminary inquiry. Again, it has suggested that there will not be any bar in granting anticipatory bail to the accused who is booked under this SC and ST Prevention of Atrocities Act. After the judgment, there was a huge violence or riots took place regarding the issue of such misuse of the law by the people belonging to scheduled castes and scheduled tribes, and it claimed lives of various people. Then the amendment of 2018 came, where the Parliament has later the SC and ST Prevention of Atrocities Act was amended in the year 2018 with inclusion of provisions that the preliminary inquiry before arresting an accused under the Act is not required. Anticipatory bail cannot be granted to an accused who is having served under this Act of 1989. All these provisions are mentioned in the section 18A of the Amendment Act of 2018, and it has been challenged in another landmark judgment in Prithviraj Chauhan versus Union of India, where the provision was challenged and has been held as violative of under section 18A. These new provisions have been added, and this was challenged in a judgment named Prithviraj Chauhan versus Union of India, where constitutional validity of the Act was challenged, but the Supreme Court had said that section 18A is constitutionally valid, and still we are unable to protect the interests of the people belonging to scheduled caste and scheduled tribe, and we are unable to bring them into the mainstream of the society to enjoy the fruits of the development. In the conclusion, we can say that it is the 21st century and all the world is thinking about the new technologies invention, 4G technology, 5G technology, 9G technology, artificial intelligence, and we people are still talking about caste-based disability, caste-based atrocities. Hence, now it is the time to eliminate all such derogatory practices by stringent legislative provision with the cooperation of all concerned citizens, and we have to take the matter very sensitively, that the participation of all people, including the so-called Dalit and the Adivasi, is very much required for our rapid socio-economic cultural growth. If we will deny their rights, then they cannot come to the mainstream and we will lose on ourselves. It is the time to bring change, and there is way, only we should have the will to bring the change. Thank you.